What do you do if you can't find the original will? Hey everybody, I'm Christopher Small. I'm the owner of CMS Law Firm. We do estate planning, we do probate, we do it well. And this is the question of the day. What if you can't find the original will? Before we get to that, I want to remind you, if you have questions about this or anything else related to estate planning or probate, and you want to talk with us over the phone for free, you can do so by going to cmslawfirm.com. Okay, so when you cannot find the original will, there are a couple of different things that you can do. First of all, this depends on your state. So if you have lost your will and you have a copy of it, you want to talk to an attorney in your state first things first, okay? In Washington state, where I am, if you lose the will, you can provide a copy of the will to the court and ask them to admit that will as if it was the original. That's hard to do though, because that comes with the presumption, a rebuttable presumption, but the presumption that the will was destroyed on purpose and should not be valid, okay? The rebuttable presumption means you have to provide evidence of some kind that the person who died, the decedent, did not intend to destroy their will. You can do this through testimony of people that say he talked about the will or she talked about the will as if she wanted it to be in place. You can present any evidence that you can find, and you have to ask the court to find that the copy of the will should be admitted. If the will has distributions that are different than if there was no will, this is something that you definitely want to pursue. I just read a really, really long TikTok comment from someone whose dad was intending to give the entire estate to a specific child and exclude a different child who was estranged from them, basically. They have the copy of the will, but they do not have the original will, and they're having a heck of a time. And as you might expect, the daughter who was estranged is fighting as hard as she can to not have the will admitted so she can take half of the estate. So in that circumstance, you definitely want to A, do your diligence, try as best you can to find the original, or B, present it to the court and see if the court will accept it. The downside to that is it's kind of expensive. There's a lot of work to be done to do something like that. You have to have witnesses. You have to, obviously argue in front of the court. So it's more expensive. If, however, the will cannot be found and the distribution inside of the will is the same as if there was no will, what we will do sometimes is just proceed without the will. For probate in general, it doesn't make a difference, will or no will, if, again, the distributions are the same. So that would sort of be option B if there wasn't anything sort of specific that was done inside of the will. Also, sometimes all of the family members are cooperative. They are in agreement that the will should be upheld, and they find a way to make sure those distributions happen sort of outside of probate. So that is, I guess, an option number 3 or option C. So if you have lost a will, all is not lost. I would definitely talk to an attorney. This is something where you need some help, some expertise, and if you don't do it right, you can miss out, okay? So hopefully this helped. If it did, that's great. As always, if you have questions about this or anything else related to estate planning or probate, and you want to talk with us over the phone for free, you can do so by going to cmslawfirm.com. That is it for today. As always, I am Christopher Small. I'm the owner of CMS Law Firm. We do estate planning, we do probate, we do it well. Thank you for your time. Thank you for your attention. Appreciate you, and I will talk to you again soon. See ya.